The chair beneath me was hard-backed and straight. I kept both feet flat on the floor and my hands folded in my lap. Across the table, my mother-in-law didn't lower her voice. She never did when she thought an audience would help. The attorney paused, pen hovering above a yellow legal pad, waiting for her to finish. "She doesn't need to be here for this," she said, turning slightly so the room followed her line of sight away from me. "This is family business." A few people shifted. Someone cleared their throat, no one spoke. My husband's father leaned back, fingers steepled, satisfied. "We've already discussed this," he added. "She was always temporary, temporary." The word landed and stayed there. I watched the edge of the conference table instead. The grain in the wood was clean and uninterrupted, recently polished. Someone had taken care with it. That detail mattered to me more than the sound of my own name being removed from the conversation. The attorney glanced in my direction, then back to them. "For the record," he said carefully, "she is legally—" My mother-in-law cut him off with a short laugh. "She helped out, we're grateful, but help doesn't get a seat at the table." There it was, spoken plainly, with witnesses. My husband didn't look at me. He stared at his phone, thumb motionless as if stillness might pass for neutrality. It didn't. I said nothing. I didn't adjust my posture or my expression. I let the room absorb what had just been declared. After a moment, I nodded once. Small, polite. "That's fine," I said. My voice didn't rise. It didn't sharpen. It didn't ask permission. The room went quiet in a way that felt accidental to everyone else and deliberate to me. Even the attorney stopped writing. No one rushed to fill the silence. They were waiting for something emotional, an objection, a plea. I focused instead on the folder in front of me, plain, unlabeled, mine. When no reaction came, my mother-in-law frowned, unsettled by the absence of resistance. My father-in-law shifted again, less comfortable this time. The attorney finally closed his pen. We sat there in the quiet they had created, and for the first time that morning, they weren't sure who was still part of the room. My name is Alina Mercer. I was 34 at the time, living in Marin County, where I'd built a life that ran on structure and predictability. I worked in commercial real estate analysis, specializing in land use and long-term valuation. It wasn't glamorous work, but it was disciplined. Contracts, zoning, ownership chains, the kind of field where details either protect you or expose you. I had been married into that family for 6 years. Long enough to understand how status operated quietly, without needing to announce itself. Long enough to see which people were treated as permanent fixtures and which were regarded as provisional, no matter how much labor they contributed. I paid my own bills, I maintained my own accounts. I'd never asked them for money, leverage, or introductions. That boundary wasn't accidental. It was a choice. The meeting was held in a private legal office in San Francisco, the kind designed to keep conversations contained. I arrived early, calm, unhurried. I wore what I always wore in professional settings, neutral, precise, forgettable. I wasn't there by mistake, and I wasn't nearly as unprepared as they assumed. What made that moment matter wasn't embarrassment. It was imbalance. From the beginning, my role in that family had been functional. I handled logistics when no one else wanted to. I filled gaps quietly. When properties needed reviewing, documents organizing, or timelines clarifying, I was the one asked to step in, not publicly, not ceremonially, but reliably. I did it because it needed to be done, and because consistency is how systems hold. When my husband's parents began consolidating assets a few years earlier, I was involved early. Not as a decision maker, but as someone who could read a balance sheet and flag structural risks. I spent evenings reviewing drafts, correcting assumptions, pointing out conflicts between stated intentions and actual clauses. It wasn't emotional labor, it was responsibility. I never confused contribution with entitlement. I understood hierarchy. What I expected at minimum was fairness. What changed wasn't the workload, it was the narrative. Over time, my presence shifted from useful to inconvenient. My input was welcomed when it solved problems and dismissed when it complicated authority. That pattern wasn't dramatic. It was gradual, predictable. There had been other moments like this before, smaller ones, conversations redirected, decisions announced after the fact. I noticed them and adjusted accordingly. Silence in those cases wasn't avoidance, it was observation. The line crossed in that room wasn't personal, it was structural. By labeling me help, they reframed years of responsibility as charity. By calling me temporary, they attempted to retroactively erase contribution to preserve control. That matters because systems depend on accurate records. When roles are misrepresented, accountability dissolves. I wasn't offended, I was clear. Fairness doesn't require affection. It requires alignment between what was given and what is acknowledged. That alignment had been broken out loud with witnesses present. Once something like that is stated publicly, it becomes factual. And facts, once established, tend to activate other mechanisms already in place. The imbalance hadn't started that morning. It had been forming for years, quietly enough that it never required confrontation. That was part of why it lasted. Early on, my usefulness had been framed as generosity on their part. I was good with details, my mother-in-law liked to say, as if that were an accident. When they acquired a second property, I was asked to review the inspection report. When a small commercial parcel came up as part of a larger estate transfer, I was asked to sanity check the valuation. These requests were never formal, they arrived as favors, they were treated as optional, but the decisions that followed reflected my input exactly. I didn't comment on that discrepancy, I didn't need to, results spoke well enough. As the family's holdings expanded, the pattern solidified. I was included before problems, excluded after resolutions. Credit moved upward, responsibility moved laterally, authority stayed fixed. That arrangement worked for them because it required no acknowledgement. For me, restraint wasn't passive, it was practical. There were moments I could have asserted position, I chose not to. Not because I lacked leverage, but because timing matters. I kept copies of drafts, I noted version changes. I paid attention to how assets were titled, who signed what, and which entities appeared repeatedly across transactions. This wasn't paranoia, it was professional habit. At one point, a parcel adjoining their primary residence came up for sale. It wasn't discussed at family dinners. It wasn't presented as strategic. It was treated as incidental. I flagged it privately as relevant. The response was dismissive, too small, too peripheral, not worth attention, so I stopped mentioning it. My role continued as expected. I reviewed, I advised. I stepped back when decisions were announced without consultation. Silence in those cases preserved optionality. It allowed assumptions to remain unchallenged. None of this was secret. It simply wasn't foregrounded. They saw me as competent but contained, helpful but temporary, someone whose function could be separated from status. That perception shaped their behavior. It allowed them to speak freely. It encouraged shortcuts. It made them careless with boundaries they assumed were symbolic. By the time the meeting in San Francisco was scheduled, most of the groundwork had already been laid, by them, not me. Ownership structures were established. Agreements were signed. Responsibilities were distributed unevenly but consistently. I didn't interpret that as hostility. It was alignment. Systems do what they are designed to do, even when the people inside them misunderstand who designed which part. My past silence wasn't hesitation, it was positioning. And when people grow comfortable believing someone else is peripheral, they rarely check whether that person is already embedded somewhere far more central than they realize. The leverage wasn't created in response to that meeting. It had existed quietly for years, built for reasons that had nothing to do with them. Early in my career, I learned to avoid direct exposure when evaluating land. I used holding structures, standard ones, LLCs layered for liability, anonymity, and flexibility. Nothing unusual, just clean separation between use and ownership, between visibility and control. It was routine in my field. When that small parcel adjacent to their primary residence came up for sale, I noticed it immediately. It wasn't large, just under 2 acres. Zoned conservatively. No structures worth mentioning. What mattered was placement, access, contiguity, the kind of land that doesn't announce its importance until it's no longer available. I purchased it through one of my existing entities, market price, standard escrow. No urgency, no negotiation drama. The seller never knew who I was. There was no reason they would have. At the time, it was simply a sound acquisition. It protected optionality. It closed off risk. In land terms, adjacency isn't decorative, it's decisive. The family never asked who owned it. They assumed it would remain undeveloped or irrelevant. Their attention stayed fixed on the house, the structures, the visible assets. That assumption wasn't encouraged or corrected. It didn't need to be. Over time, additional agreements referenced access, easements, and shared boundaries. Standard clauses, boilerplate even, they were reviewed quickly, initialed without discussion. No one flagged dependencies because no one believed there was a dependency to flag. There was. Ownership of that parcel didn't grant me power over them. It granted the system clarity. Certain rights existed, certain limitations followed. None of them punitive, all of them enforceable, and none of them reversible without formal process. I didn't hide this. The entity was properly registered, taxes were paid, records were public, it simply never occurred to them to look. By the time they decided I was just the help, the structure had already matured. The land had already been integrated, legally speaking, into how their primary asset functioned. I didn't need to activate anything. I only needed to allow existing mechanisms to surface. That's the advantage of working within systems. You don't apply pressure, you remove the assumptions that were holding everything in place. The shift didn't happen when I spoke. It happened when the attorney cleared his throat and adjusted the folder in front of him. "We need to address a property dependency before proceeding," he said, tone neutral, procedural. He didn't look at me. He didn't need to. My mother-in-law frowned. "What dependency?" The attorney slid a document across the table, thick paper, tabbed. He waited until it stopped moving before continuing. "The primary residence relies on an adjoining parcel for access, setback compliance, and utility easement. That parcel is not held by the family trust." My father-in-law leaned forward. "That's not correct." The attorney nodded once. "It is." Silence settled in, not dramatic, just dense. I stayed where I was, hands folded, eyes level with the table edge. The attorney continued. "The parcel was acquired 8 years ago through a holding entity. It is legally independent. Any transfer, restructuring, or leverage against the primary residence requires consent from that owner." My husband finally looked up. "Who owns it?" The attorney checked the document, though he already knew. "Mercer Holdings, LLC." No one reacted immediately. They were still translating. My mother-in-law laughed, sharp and brief. "That's not a person." "No," the attorney agreed. "It's an entity." Her gaze moved to me. "Is this a joke?" I didn't answer. I didn't shift. The attorney did. "Miss Mercer is the managing member," he said. "The documentation is clear." My father-in-law stood halfway, then stopped, palms flat on the table. "You're saying she controls?" "I'm saying the system recognizes ownership," the attorney replied. "Control follows from that." Voices overlapped then, questions, objections, accusations that weren't quite formed yet. The attorney raised a hand, not to stop them, just to pace them. "These clauses were signed," he said, tapping a page. "These easements were referenced. No misrepresentation occurred." My mother-in-law turned fully toward me. "You planned this?" I waited a beat, long enough to be intentional. "No," I said, "I planned responsibly." That was all. The room fractured after that. My husband spoke quickly, then too quickly. His parents contradicted each other. Someone asked about reversals, another about urgency. The attorney answered each question in order without inflection. Consent requirements, regulatory exposure, timelines measured in years, not meetings. At one point, my mother-in-law lowered her voice. "You can fix this," she said. I met her eyes for the first time that morning. "The process is already in motion," I replied. Then I stopped. The attorney closed the folder. "At this stage," he said, "there's nothing further to discuss today." No one argued with him. I remained seated as they gathered papers they no longer controlled. No one asked me to leave. No one asked me to stay. By the time the room emptied, the outcome had already detached from emotion. What remained was record, authority, and a structure doing exactly what it was built to do. The first challenge came quietly through counsel. Formal letters, careful language, requests framed as clarification rather than resistance. They were answered just as carefully and just as slowly. Nothing moved quickly because nothing could. Within weeks, a temporary pause was placed on several planned transactions. It wasn't punitive. It was procedural. Certain approvals couldn't proceed without consolidated access agreements. Those agreements required signatures that weren't forthcoming. By the end of the quarter, timelines began to slip. Contractors were rescheduled. Consultants revised forecasts. Carrying costs increased in small, measurable increments. No one announced the change. It showed up in spreadsheets. An attempt was made to restructure around the issue. That failed at review. The dependency was embedded. Removing it would have required years and regulatory variance that wasn't guaranteed. A few months later, financing terms were revisited. Conditions tightened. Nothing dramatic, just enough to reduce flexibility, just enough to make leverage visible where it had previously been assumed. The legal route followed. Motions were filed, arguments were made, each one stalled on the same point. Ownership was clear. Authority had been properly established. No misrepresentation could be demonstrated. Appeals were considered and quietly set aside. By the end of the year, the practical effects became visible. Travel slowed, staff changed, invitations declined, conversations shortened, access narrowed. I wasn't present for any of it. I didn't receive updates directly. Information arrived the way it always does in professional circles, indirectly, stripped of commentary, reduced to outcomes. One notice stood out. A routine filing confirming continued compliance with existing agreements. No changes approved, no exceptions granted. That was the moment it became clear that nothing would be reversed. Systems don't respond to emotion. They respond to documentation, timing, and consistency. Once those align, outcomes tend to settle. And settled outcomes rarely invite further discussion.